In July 2013, the Department of Justice and the FBI agreed to audit microscopic hair comparison in partnership with two outside organizations, the Innocence Project and the National Association of Criminal Defense Lawyers. This arrangement placed defense-side organizations inside the room, working as partners to read the trial transcripts. DNA testing made this audit possible, providing an objective tool to check old hair associations against biological reality for the first time. The practical work was an archival excavation to find physical paper. To see what an examiner actually told a jury, investigators had to find trial transcripts from decades-old cases, often scattered across dozens of different local jurisdictions. Locating that testimony took years, which is why the review's numbers were constantly shifting as more documents were unearthed. On April 20, 2015, the Department of Justice, the FBI, the Innocence Project, and the NACDL issued a joint announcement detailing their first substantial findings. These figures represented a March 2015 snapshot of an unfinished process. The release explicitly warned that because the review was ongoing, these numbers would change. The government had identified nearly 3,000 cases in which FBI examiners may have submitted reports or testified. At the time of the snapshot, about 500 had been reviewed. Within that group, the audit isolated 268 specific cases, where an examiner's testimony was used to inculpate a defendant at trial. In 257 of those 268 cases, the audit found erroneous statements. That is an error rate of 96%. The metrics extend individuals behind the work. 26 out of 28 FBI agents or analysts had either given testimony containing erroneous statements or submitted laboratory reports containing them. In at least 35 of the cases reviewed by the time of the snapshot, the defendants had received the death penalty. Errors were identified in 33 of those capital cases, 94%. According to the Death Penalty Information Center, 9 people whose convictions partially relied on improper hair comparison had already been executed, and 5 more had died in prison. This 96% error rate specifically tracks how often the language used in court exceeded what the science could support. It measures the testimony rather than the accuracy of hair comparison as a technique. The audit established a firm boundary between testimony and outcomes. Erroneous testimony does not automatically equate to a wrongful conviction. While an examiner may have described evidence improperly, that does not prove the defendant was innocent or that the hair decided the verdict. The vast majority of the defendants in those 257 cases were never exonerated. The numbers also remained in motion. The final count never settled into a single clean total. By June 2018, independent data showed 450 errors in 484 transcripts. When the FBI concluded the review in August 2019, they had checked 23,547 cases. Despite this massive final count, no updated percentage ever replaced the 2015 headline figures. Regarding the executed individuals, the record is equally specific. Their convictions partially relied on this testimony. No source has established that these executions were wrongful. The count identified a practice rather than a villain. It quantified a decades-long institutional failure, accepted by courts lacking any competing method to test against. The fundamental question, how often is this wrong, went unasked until outside technology and defense attorneys began reading the transcripts. This is the final receipt, an error rate of 96% in the cases where transcripts could be found, and a count that was still moving when they stopped.